Waltree Complex in Indiana, and I am joined by our co-moderator, Ellen Quick from the Center for Economic Operations for this next 20 or 25 minutes. Ellen, good morning.
Good morning, everyone.
We would just like to briefly inform our listeners on the radio on 1160 and also here in the auditorium what this next 20 or 25 minutes will consist of. As landowners here in Indiana County in our region, many opportunities have presented themselves that deal with the recent shale gas and Marcellus shale activity. Of course, if you're a landowner, you have questions, you have expectations, you want to know what's involved with the pipeline and some of the testing agreements that have been in the news lately, and also you'd like to know if you can be compensated for some of that. These are some of the questions that landowners are seeking the answers for. Hopefully, through our panel up here, we will be answering some of those questions today. Oil and gas operations in Indiana County and our surrounding area can be a financial plus for landowners as long as you know the drill. And at this time, we're just going to go down our table here located on the stage of the Toretti Auditorium, and I would ask our panel to introduce themselves and let everybody know who they are representing this morning.
Good morning. As I mentioned, I'm Ellen Quick, the Economic Development Specialist for Indiana County.
And I'm Malcolm Polly. I head the Wealth Management Division for S&T Bank.
Wes Turiano, I'm the Director of Mineral Management at S&T Bank.
Bob Burnett, I'm an attorney from Pittsburgh at the law firm of Houston Harbaugh, and I head up our oil and gas practice group.
And we welcome our panel here to our discussion and on the radio this morning during our PA Gas Expo. We have some questions that we're going to start with, and we'll direct our first question to Malcolm Polly. Now, Malcolm, somebody that's, say, a 50-year-old gas lease, they've had a producing gas well on their property for some time. The royalty checks are very minimal for those folks. What can they do to take advantage of the opportunities with Marcellus shale?
We see that a lot, particularly in the trust department, where we've got folks that have got long, old leases that have been producing for a lot of years, and in many cases, they aren't producing much revenue. We might go several months without getting a check, and when we do get a check for a client, it's $25, $50 or so. So we think the best opportunity for people today is when a gas company approaches you to change something, they want to do something else. That really gives you an opportunity to go back in and look at the lease. And I actually think that either Wes or Mr. Burnett, who see this much more often than I do, would probably be able to add some color to that.
Well, just looking down our questions here, our next question concerns our lease agreements. And Wes Turiano, if somebody is already under a lease, what can they expect, or what else do they need to be prepared for the oil and gas process?
Well, I think that a common misconception that a lot of landowners tend to have is that once you sign a lease, that you're done with the process. And really, that's the beginning of it. You're going to be faced with other things, such as pipeline right-of-way agreements, which you really can't minimize the importance of. Seismic testing agreements, potential amendments or ratifications to an old lease. In this area, you have a lot of old leases with Phillips, PC Exploration, and TW Phillips, and Cribble, and all these companies that have been around for a long time. And a lot of those leases don't allow for pooling and unitization, which is necessary for a Marcellus well. A lot of those leases are based on flat rate royalty payments, X amount of dollars per month, or semi-annually, or annually, whatever the case may be. Of course, with new legislation, the state minimum royalty is 12.5%. So there may be an opportunity for a landowner to amend or ratify an existing lease document. And that's really an opportunity for a landowner to get something changed for their benefit whenever a oil or gas company needs something changed for their benefit.
You know, Wes, if I could chime in, can you talk a little bit about the obligations that a landowner might be required, when entering into contracts such as this? Or perhaps, Bob, that might be more directed towards you. Are there responsibilities on the part of the landowner as well?
Well, there can be. Oftentimes when we negotiate leases, when the gas company presents a lease to a landowner, they often put an obligation on the landowner to warrant the title the oil and gas mineral rights, that they are going to warrant that they do own them. And if there is a defect in the title, the gas company will try to push the risk onto the landlord. Oftentimes we try to negotiate that term out of the lease and put that back on the gas operator, that we shouldn't be required to conduct a title search going back into the 1800s, verifying our oil and gas mineral rights. Other than that, a lease will set up the parameters between the landowner and the gas company. Obligations that might be on the landowner might be providing surface access, reasonable access, not denying or contesting well site locations or pipeline locations. And again, in the lease document itself, we try to create a mechanism by which both parties have input as to where things are going to go and how things are going to be conducted in the lease.
And if I could chime in with one more thing there, things that a landowner may expect or post-leasing issues that a landowner may encounter. Bob sees this a lot. We've worked with Bob on this for some clients of ours. Again, old leases, things that are red flags are periods of non-production. If you don't receive a royalty check when you're due to receive a royalty check, that should throw up a red flag. Bob will touch on this a little bit, I'm sure. Pennsylvania has a law of implied covenant or an implied development where a company is responsible for developing the property. I'll let Bob talk about that a little bit. Another issue that Bob faces that we see all the time, you've got 100 acres, but only 5, 10, 20 are included in a drilling unit. What happens to the rest of the acreage? Again, a significant legal issue that needs addressed.
Yeah, thanks. So one of the biggest issues in a non-productive lease that we look at is how long has the well not been producing? In Pennsylvania, we follow what is sometimes known as the automatic termination rule. And once a lease gets beyond its primary term, and you get into the secondary term, if there are any periods of non-production under the lease, arguably the lease automatically expires. Now, there could be provisions in the lease that prevent or save the lease in the event of non-production, but if you have an old lease, 20, 30, 40 years, and there have been periods of non-production, you did not get a royalty check for a period of time, an argument can be made that that lease expired. And there are many landowners in Western Pennsylvania that are completely unaware of that and operate under the misconception that a lease once signed lasts forever. It can last forever. That well produces gas in paying quantities. The lease will go on as long as that well is producing. But if there is a period of time of non-production, landowners have to be very careful to assess their royalty checks and their royalty stream, because if the well is not producing, an argument could be made that the lease expired many years ago. And even if it's discovered today, a period of non-production 10 years ago, that could give rise to terminating the lease.
We are News Talk 1160 WCCS. We're broadcasting live this morning from the Torrenti Auditorium. It's our PA Gas Expo at the Comanche Complex here in Indiana. And we invite anybody in the listening area to join us today. The event is free of charge. Lots of information. You can have your questions answered. This is our first panel discussion, and we'll have some more coming up. The next one will be at 10 a.m. here this morning. Our next question we'd like to direct to Robert Burnett. For folks that do not have an oil or gas lease, and they have not been approached by gas companies in the past couple of years, are any companies in the area leasing right now, and what can they expect to be? Can they expect to have any of this land leased in the near future?
Well, what I'm seeing in my practice is across the board, the leasing activity here in Western Pennsylvania is slowing down. Gas prices are at a historical low, and many of the gas operators are suspending or at least scaling back their leasing programs. Now, it's not to say that gas leasing activity will pick up in the future, but I know for a fact a number of the gas operators have actually suspended leasing programs altogether.
Now, something that's not on our list, but I think maybe we take for granted, anybody with land should have some good legal representation to talk about these contracts and leases, correct?
Well, I would say that an oil and gas lease is a sophisticated and complicated legal document, and that any landowner should seek out counsel in regards to negotiating and or interpreting provisions of that lease.
And from my perspective, you need to be very careful of the type of counsel that you retain to help you with your leasing activities. I know there are a lot of generalists that say they do oil and gas business, and they may have done a small amount of it. But even though the oil and gas industry was founded in this state 150 years ago, I mean, it really essentially ended in this state almost 100 years ago when the oil fields got dried up. So in many ways, the legal framework for the industry in this state is way behind the times, and the state is playing catch-up. So hiring firms that have specific areas of expertise in oil and gas, and we think is very important.
On our panel this morning, it includes Malcolm Pauley from S&T Trust. And Malcolm, folks that have been receiving royalty and free gas for a number of years, how do they know that they've been paid correctly for the gas that's under their property?
A lot of people don't, which is one of the reasons we got into the mineral management business, is that the provisions of what is included in your royalty payment are included in your lease document. So do they take out compression costs? Do they take out other marketing costs or the cost of getting your gas from the wellhead to the ultimate location? A lot of that's spelled out, and most people don't take the time to look and see, okay, they paid me $2 an MCF for my gas, but they took all these other deductions out. What does that mean? We can step in and help people, and where really Wes focuses a lot of his time, and a lot of the folks in our mineral management focus their time is making sure that the deductions that are taken out of your royalty payment are correct deductions. In fact, there have been a number of lawsuits in the state of Pennsylvania against gas companies for not paying royalty owners the correct amount in the royalty payment. So we think it's very important to pay attention.
And that is where your legal counsel would help you.
Exactly.
Things like that. Our co-moderator this morning for our broadcast from the Gas Expo is Ellen Quick from the Indiana County Center for Economic Operations.
Thanks, Chuck. You know, I thought of a question, gentlemen. Where would a landowner begin in this process? Would they want to start with a mineral management services firm such as S&T, or would they want to approach legal counsel first? What's the first step in this?
Well, I'll give you my 2 cents on that. We put a little bit different spin on it than a lot of businesses do. If you're unleased and you've not been approached, one of the things